Estate planning has special terminology that I want to go through up front because I'm going to use it throughout the series of videos to explain things. So this will be a fairly quick. Estate planning itself is the process of giving away property after or in anticipation of one's death, is pretty much what it is. Estate, that's the legal entity that holds title to assets after the owner dies and before the property is distributed. You may have seen reference to things like the estate of Mark Jones. If somebody has, even in court, if somebody has a claim against Mark Jones himself and Mark Jones passes away, the estate then has to be substituted in, and it would be so-and-so versus the estate of Mark Jones. So, because the estate will then take control of Mark's assets, and that would include any money or bank accounts and such. So, the estate. The decedent is the person who's died. Testator or testatrix is someone who has signed a valid will. The testator is someone who has signed a valid will. Testatrix is the female version. I put it on here. We don't really use those terms anymore. It's kind of old terminology. We just stick to testator. But nonetheless, it is still used in some courts, so that's the distinction. We have the same distinction with executor and executrix, and it's really tricky to say too. Intestate, I already introduced that in the last video. When somebody dies without a will, they've died intestate. An heir is someone who inherits from a decedent who died intestate, meaning without a will. It's the person who stands to receive under state law is an heir. I know that is a very flexible term now. It gets used just regularly with a will or without a will. But proper terminology here, heir, someone who inherits from a decedent who died intestate. A devisee is someone who inherits real property under a will. So if you own a home and you have children, if you have prepared a will and you die, and let's say you left your home to your child would be the devisee because you left real property. Legatee, a person who inherits personal property under a will. So instead of the home, you had a car. Same, the person who stands to inherit would be the legatee. Legacy or bequest is a gift of personal property by will. A devise is a gift of real property by will. And then we have issue, and an issue is a person's direct decedents. So if you have children and your children have grandchildren, all of those folks are considered issue. Probate, when we say probate, I use that term, it's the process of carrying out the terms of a will. We have a probate court or surrogate's court, as we call it. We don't have probate court in New York State. It's referred to as surrogate's court because other things besides probating wills happens in surrogate's court. But surrogate's court or probate court is the court that has the power, the authority, or jurisdiction over the settlement of estates. And then here's our executor, executrix. A personal representative who the decedent has chosen. They actually have to choose this person to carry out the terms of the will. So in their actual will, they'll say, so-and-so is my executor. And if there isn't somebody who is named in the will as executor, then the court has to appoint someone, and they appoint an administrator. So an administrator is a personal representative appointed by the probate court to oversee the probate process for someone who died without a will, intestate, or if somebody failed to appoint an executor, it'll be the court that will appoint somebody. Grantor or settler is someone who creates a trust And donor is someone who makes a gift or creates a trust. So those terms, donor, grantor, settlor, are all kind of used interchangeable, but they are related to the creation of a trust. What is the purpose of estate planning? So estate planning has two primary purposes: to ensure that property is distributed as the owner desires and to minimize estate taxes. Now, tax issues are outside the scope of this topic, but it is an important element of estate planning, and it's one of the ones that's generally taken into consideration the most, especially if somebody has lots of assets. So people consider it when they're determining how to transfer their property, and in some instances, who to transfer it to, because sometimes the person who is receiving it might have a tax implication. Like I said, wealthy people might set up a trust, because trust allows for the passing of money that could be tax-free, or they might be able to give it to charity. So while taxes are outside the scope, it is one of the primary reasons why people plan for the distribution of their property. So their estate isn't taxed heavily like in Prince's case, and to avoid the people who are getting transfer of those gifts or assets don't suffer consequences of being taxed. The federal government and many states, as I said just before, levy estate taxes. Traditionally, state taxes have been lower. States' probate laws are what govern. Their laws, their codes, they regulate the creation of wills and trusts, not the federal government. But what this means is that codes can actually vary from state to state. So it's important to know the particular state code you are working with when setting up or creating estate plans that include wills and trusts. So for this purpose, the topics we're going to discuss here, we're going to talk generally what the trends are among states. I will impute my knowledge relative to New York law, but the point is, know the law in the state you are working for. So with that, we're going to move on to wills.